So it's always lovely to see you, right? And you seem to be quite energetic, enthusiastic. Yes or no? Great. At least for namesake, say yes. I hope that's not for namesake. Yeah? Okay, great. So as usual, we'll do a recap first before we move on to the new concept, isn't it? Right. So what did we discuss in our previous session? We talked about some legal terms, if you remember. Anna. So what are those terms which we talked about? Sir, misfeasance we talked about, which is breach of duty causing loss to others. Simply breach of duty is not misfeasance. Causing loss to others. Then the effect of this is disgorgement, meaning recovery of wrongful profits earned or compensate the loss. Good, fantastic. Overriding provision, come on, which enjoys supremacy over some other provision. So other provision means only a few provisions, or the chapter, or the act, or all the acts. That's also possible, no? That's also possible. Good. Subject to, come on, dependent on some other provision. So we said, like overriding says, listen to me, whereas subject to is like, yeah, we'll have to follow something else as well, then only we'll say this is complied with. Correct? Very good. Then we talked about even injunction. Correct? What is that? Stay. In short, we said it, nothing but stay. Good. Then convict. Correct. The person found to be guilty. And whereas if declared or found innocent, that means acquittal, acquitted, convicted, isn't it? Great. Then, so convict and acquit are opposites. Then decree, court order. So when the judgment is in favor of plaintiff, right, we can use the word upheld. Whereas held word can be used either ways, whether the judgment is in favor of plaintiff or defendant. But upheld you have to be careful because that can be used only when decision is in favor of plaintiff, as you rightly said. Next, cognizable offense. Come on, two meanings to it. One, sir, they can arrest the person without even warrant or court order. That's the first meaning. Second, yeah, conditions. So they'll admit the suit, they'll admit the petition subject to some conditions. If conditions are fulfilled, then yes, they will accept. Otherwise, they will not. Good. Non-cognizable obviously is opposite of it. That means warrant is needed, order is needed, and then secondly, no conditions and all for admission of a suit. Then coming to compoundable or non-compoundable offense. Very good. Compoundable is fine in lieu of prosecution. So prosecution, the court proceedings, the trial in the court, isn't it? So you can pay fine and leave, no need of prosecution when we say the offense is compoundable. And how do you identify that? Right, fine only, fine or imprisonment, or both. Right, so when any contravention leads to this, then we say compoundable offense. Whereas when it is imprisonment only, fine and imprisonment, that means it is non-compoundable offense. Very good. I bid, ditto, same as above, comes from the Latin word I bid him. I bid him. Correct. Bona fide and mala fide again are opposite. Mala fide means obviously bad intention, wrong intention, evil intention. Bona fide is opposite of it. So good intention, when we talk about, that is where we say bona fide. Ipso facto, by the mere fact of it. Good. Modus operandi, mode of operation. Correct? Yes or no? What is the modus operandi of Bajaj Electronics? Come on, someone asks you what is the modus operandi. So you'll say they have a showroom. So physical store is there. We can go and buy from that physical store. Maybe they have a website, so we can order sitting here online. That also is possible, right? So we understand mode of operation is nothing but modus operandi. Then de jure, meaning by law, by right. Whereas by fact, de facto, mutatis mutandis, suitable modification, right? With suitable modification. Like we gave the example of articles memorandum. You know the definition of articles. Then you can say mutatis mutandis you do, you will get the definition for memorandum. So can you recall the definition of articles? Articles means articles of association, as originally framed or altered from time to time in portions of the act. So here in this full sentence, what needs to be changed so that we get the definition for memorandum? Articles needs to be changed to memorandum. So if I say memorandum means memorandum of association, and then the same thing, that's enough. That's where we said mutatis mutandis, suitable modifications. Very good. Fantastic. Right? Yes, sir. Then we talked about public interest, if you remember. We said interest of all the stakeholders, all the sections of the public. Right? When we're talking about in public interest in the context of company law. So we said shareholders, come on, financial creditors, trade creditors, employees, workers, the board of directors, that is the management, customers, competitors, like that. We have n number of sections in the public. So whose interest is involved? Then we say public interest is involved. All the sections of public or majority of the sections of public. Correct? That is where public interest. Wonderful. Then if you remember, we started with company law, Companies Act, isn't it? Is there a difference when I say act and law? Yes, I've told you. Which one is wider? Law. Because law will include not just act, but also rules, notifications, circulars, case laws, all of that, isn't it? Even some orders. Then yes, my dear live students, a very good afternoon. Yeah. Now coming to the word construction, which I have written there. If you recall, construction means what? Reasonable interpretation. Reasonable interpretation, literal interpretation. Which one we follow? Sir, literal we follow. However, if literal doesn't help us in achieving the objective, that is where we shift to reasonable interpretation. That means we go beyond the words. Am I right? We go beyond the words. So when you stick to the words, it is literal interpretation. Go beyond the words, then it's reasonable interpretation. Reasonable interpretation is construction. So we use the word construed, meaning understood, interpreted reasonably. Okay, right. Then history we talked about of Companies Act. So we said we have only, come on, Companies Act 2013. No sir, before that we had Companies Act 1956, and before that, right, so it started with 1850, 1866, 19, no sir, 1882, then 1913, 1956, and now the current one, 2013, right. And this is a rule embedded law, am I right? And why did we get this 2013 Act? Sir, there were many reasons, right? To be specific, we said improve corporate governance, simplify the regulations, bring the concept of OPC, small company, bring even the concept of rotation of auditors so that independence can be maintained, isn't it? Plus corporate social responsibility. How can we forget class action suit, NCLT, NCLAT, special courts as well. Okay, like that there are a few reasons. Even NFRA, right? NFRA, National Financial Reporting Authority. Right? So we understand for these things we have got the new law. So when do you think they get amendment? When do you think they get Amendment Act? When do you think they get a new law, new act? Come on, when number of amendments are less, then notifications. When number of amendments are more, Amendment Act. And when huge, then to new law, correct? Then it's new act, new law. So see, we could understand huge number of changes, right, were required. That's where they thought of a new act itself, and that's where we got Companies Act 2013. Okay, what's the full form of SFIO? Serious Fraud Investigation Office. Which chapter we are going to read? I. Maybe you don't know the number, that's fine. But inspection, investigation, inquiry chapter, no? Yes, sir. Then, what is class action suit? You remember? Suit filed for some action by one class of members or depositors who are impacted the same way, the uniform way. And they want action also the same way. Good. And when it comes to NCLT, it's only that they have changed the name of CLB to NCLT, correct? No, sir, not like that. I've told you that we have concept of benches, isn't it? This is a quasi-judicial body. Yes or no? What about NCLAT? It is a replacement for High Court. Meaning, earlier we used to say appeal before High Court in case you are not happy with the orders given by Company Law Board. Now we say, if you're not happy with the orders of NCLT, go to NCLAT. Okay, is it possible directly approach NCLAT? Yes, in exceptional cases that might also happen. Directly you can file a case with Supreme Court, High Court. It happens, no? Same way here also it is there. So don't think NCLAT is only a revisionary authority. Okay, it is not. Sometimes even primarily only you'll file the case with NCLAT. Thousands of crores is involved in some scam. You expect NCLT, then NCLAT and all. No, sir, directly it might go to NCLAT, or who knows, directly it might go to Supreme Court as well. So one has to understand, generally this is the hierarchy, but there can be exceptions as well. Okay. Okay. Why High Court now changed to NCLAT, meaning in company law? Sir, quality of decisions, yes, and reduce the burden of High Court. Already they are burdened. They wanted faster disposal of the cases. That's where they got NCLAT. Very good. So if someone asks you what's the rank, what's the level of NCLAT, what would you say? High Court. It's replacement for High Court. So obviously it's the level of, so you'll find retired judges of High Court and all, or retired, what do you say, judicial body of High Court will be there in NCLAT. Understand? Okay. Then we have compared 2013 with 1956 from three perspectives, right? Number one, preamble if I talk about. So it was earlier, consolidate and amend the law relating to companies and certain other associations. But then when it comes to 2013, consolidate and amend the law relating to companies. What about other associations? They're anyways covered. A is equals to B, B is equals to C, implies A is equals to C. Same way we said, obviously they are saying that consolidate and amend the law relating to companies. So which was that law which they wanted to consolidate and amend? 1956. And 1956 anyways talks about certain other associations. Am I right? Fantastic. Then we have scope. We talked about scope. So earlier we had some parts, right, comprising of some sections, and even schedules were there. Now also we have parts. No, sir. Now we have sections and schedules, but those sections are grouped into chapters. So the act is divided into chapters, or I can say the sections are grouped into. Please understand the difference. You don't say chapter is act is grouped into. You'll say act is divided into, but sections are grouped into. Right? Understood? No? Because you are clubbing group of sections into one and calling it as chapter. But as far as act is concerned, you're dividing into various chapters. Right? So how many chapters in Companies Act 2013? 1 to 29. Sections 1 to 470. Schedules 1 to 7. Isn't it? Then section 1. So title anyways there. The Companies Act 1956. Same way the Companies Act 2013. Next, extends to whole of India except for suitable modifications for state of Nagaland earlier, but now it is only whole of India. Next, come on, commencement date was given, such date as may be notified by CG in official gazette. What do you mean by CG? Very good, MCA. Thank God you didn't say central government today. So that's the spirit. And when it comes to, come on, 2013, when it comes to, right side boss, 2013. Sir, first of all, they have given applicability also this time, which was not there earlier. They have clearly mentioned here that this act applies to not just companies which are registered under Companies Act 2013, but also previous Companies Act, or electricity company, banking companies, insurance companies, or any other company governed by some special act, plus such other notified body corporates as well. Correct? So if they want to notify some other body corporates to come under company law, that can also happen. So where will the notification be given? Notified, that means notification. Official gazette. What is official gazette? Official newspaper released by government or government agencies, government department. Right? Okay. Then what do we have? Come on. Such date as may be notified by CG in official gazette. So you remember what does this line mean? Such date as CG may notify in official gazette. Law is implemented in phases. So Parliament is giving the authority to the government, to the ministry, that you decide when do you want to implement the provisions, isn't it? So that's where such date as CG may notify. Clear to you? Clear to you? Fantastic. Now let's proceed and talk about the list of chapters. I've told you, we'll be seeing how many chapters, 1 to 29. So we'll see what are those chapters all about and what is there in our syllabus as well. As such, we know the syllabus. Now we'll search in this list of chapters which chapters do we have. But before that, first list of chapters. Okay. So chapter number 1. Don't know. Preliminary, basic, section 1. Come on to section number 2. Correct. So preliminary is that first chapter. Second, incorporation and incidental matters. Come on, continue. Third one. Right. So first one basic, yes sir. Second one incorporation and incidental matters. Incidental matters meaning, sir, memorandum of association, articles of association, certain doctrines we talk about. So connected matters, incidental, connected, related. Okay. Oh, relating to incorporation, fine. Then third one you said prospectus and allotment of securities, meaning, sir, they after incorporating the company obviously would like to do fundraising. For that they will have to allot securities, and for that they will first issue prospectus. Prospectus is invitation to offer, and then after reading the prospectus, if someone subscribes, that means he is giving an offer, and then company will give his acceptance. Company will give it acceptance in the form of allotment. So when they allot, that means they have accepted. That is where contract comes into place. What do they allot? Securities. Securities, not just shares. There can be other than shares as well, right? So prospectus, allotment of securities. Fine, son. So we have provisions relating to this as well. Fourth, share capital and debentures. So securities, when we say, we think of shares, we think of debentures. So next is share capital and debentures. Then money may not be enough, so thereby deposits. They may go for even deposits. Sir, we know when we take some loan, we have to provide security. So company also, do you think when they issue debentures, is it that they have to provide security to the debenture holders? Yes. And what is that called as? Charge. So registration of charges, chapter number 6. Oh, provisions are for creating security, and that security which is created needs to be registered also. Registered with whom? ROC. Who's the mother of company? ROC. So why are you calling ROC as mother? First, don't you think you need to update your mother from time to time about your life? She'll ask questions or not? You will also inform her or not? Father maybe doesn't have so much of time or is not interested also, but mother very much interested. Same way for companies, don't you think important events, important matters, important transactions need to be informed to ROC? Yes. So that's where I'm saying ROC is the mother. Anything wrong? Yes. But in the exam, will we write mother? No. Obviously, there we'll write ROC. Good. Then management and administration. This includes general meetings also. Correct. This includes general meetings also. Okay. So this includes, I'll write here, general meetings. Can you see this now at least? Right. It includes general meeting. That means it doesn't have board meetings. When we are talking about management and administration, we are talking about only general meetings here. Where are provisions relating to board meetings given? Sir, chapter 12, right? Board meetings, directors related chapters we'll have, isn't it? That much idea we have or not? Should not have, now at least you should have. Okay. So management and administration, general meetings related. Then dividend, provisions relating to dividend. So company wants to give dividend, distribute dividend, they can do it the way they want? No sir, they'll have to follow the provisions. Accounts of the companies, meaning company want to maintain books of accounts. Can they maintain the way they want? No sir, again they have to follow the provisions of chapter number 9, and those books of accounts needs to be audited. Okay, now tell me those 10 chapters. So if you have some logic in mind, some clue you set, you'll remember it easily. First we said preliminary basic. Then immediately after that incorporation. So we have to talk about related matters also. Then once company is formed, I'm giving you the clue now. Once company is formed, we would like to allot securities for that issue of prospectus. Then when we say securities, obviously it is shares and debentures. But as I've said, money may not be enough. That's where they may go for deposits. Okay, sir, they've got the money through shares to debentures to deposits. But then debenture holders will expect some security. That is where we talk about charges. Okay, money raised. Now what? Start business, sir. Right? That is where management, administration, general meetings. In general meeting, what will the members expect? Our dividends are. And those dividends will be decided on the basis of profits. So for that they have to maintain accounts, sir. And those accounts needs to be audited, sir. Otherwise, how will we know those accounts are correct or not? So that's where we talk about audit as well, right? 9 is accounts, 10 is audit and auditors. Will you remember all these 10? Yes, sir, very easily. Now the question comes, who will manage? Board of directors. So now the chapters relating to directors begin. 3 chapters, 11, 12 and 13. First, we talk about directors appointment and qualification. Yes, sir. First, we have to appoint. So that means we'll have to check any disqualifications are there, any grounds are there. Okay. And then, sir, once appointed, they need to have powers. They need to have restrictions. And then we know it's not that only one director will do things. It is board of directors. So that is where we are saying board of directors, meaning board meeting, and then powers and restrictions. And then some face is needed, some CEO, some CFO, some CS. So we talk about managerial person. And do you think they'll work free of cost? They'll not need any consideration? No. So we talk about remuneration as well. So that is chapter number 13. So what is 11? Directors appointment qualification. 12, board meetings, powers and restrictions. 13, managerial person and remuneration. In short, you can also say managerial remuneration, because people call this topic as managerial remuneration. Nothing wrong. Okay, that's an arrangement, or what do you say, agreement done. All right, sir. Now, is there a chance that audit done, but then still something not found out because the objective is different in audit? Remember, what was this sign for? Watchdog. Told you, I think, right? Auditor is a watchdog, not bloodhound. Who's bloodhound? Investigating officer. So if through audit they didn't get to know about something wrong and they have some sort of doubt, then what will start? Right, investigation. So inspection, inquiry, investigation. These 3 are right. So directors 3, then inspection, inquiry. And then they might get to know that there is some arrangement done by way of which they were doing something wrong. Correct? They were mismanaging. So 15th chapter, compromise, arrangement, amalgamation. 16th chapter, prevention of oppression and mismanagement. Tell me. 11, directors appointment and qualification. 12, board meeting, powers and restrictions. 13, managerial person and remuneration. 14, icai, inspection, inquiry, investigation. 15, arrangements. So compromise, arrangement, amalgamation. 16, prevention of oppression, mismanagement. Why did we say investigation will start? Because there's some arrangement, there's some mismanagement. So that itself is a clue that next 2 chapters are this, no? And then how much mismanagement has happened? So that's where registered valuers, chapter number 17, registered valuers, valuation. Okay, the next question would come now, mismanagement, but to what extent, to what tune? Okay, valuers, right? And they find that yes, there is some fraud, there is some mismanagement. What can they do? Strike off the name. So defunct companies. Have you heard of defunct companies? Come on, defunct companies. ROC has the power to declare the company as defunct. That means removal of name of the company from register of companies. So in short, people will say chapter 18 is defunct. Don't write anything, okay? Now seriously, you don't have to write. Wait. Anyways, come back. So defunct companies. Then you'll say, sir, there is another possibility. Maybe that company, because of mismanagement, is getting sick. So next one. sick companies, right? And what do you do when you fall sick? We said go and jump in Tangman, then drink some poison. No sir, we go to the doctor and get, yeah, so we try to recover. Same way, when businesses get sick, what do you think of? Revival, rehabilitation. So that's where revival and rehabilitation of sick companies. Then comes 20, chapter 20. Any idea? Winding up. Winding up. What do you mean by winding up? Closure. Rather, I would say process of closure. It's not closure, it's process of closure. And when it gets closed, dissolved, dissolution. You understand? The result of winding up can lead to dissolution. That means closure. So process of closure will lead to closure. Understand? Now let's say it's 9 o'clock in the night. They have to close the academy. What will the security guard do? Just lock the gate and go? No. He'll come to each floor, check each of the class, switch off the lights, AC and whatever is switched on, check whether any student is there, and if no one there, switch off all this, lock it floor by floor, and then finally lock the gate. So there's a process of closure, and then finally you can say, yes, I have closed. Same way, when you're talking about company's closure, we're talking about certain steps, process, that is winding up. That may lead to dissolution. Achha, is there a possibility that without winding up also company can be closed? Yes sir, maybe. Like without coming onto each floor, directly watchman locks the main gate. That can also lead, right? There's a possibility. See, whether it is right or wrong, that is a different story. But can it lead to closure like this? Yes. Same way you'll find sometimes maybe company will get dissolved without even winding up. So that's why it's important for you to understand winding up is not closure. Winding up is process of closure. Okay. And in that, one of the important steps involved is liquidation. In winding up process, we have liquidation. What is liquidation? Yeah, selling of the assets, realizing the money, recovering the money from those debtors and all that, right? For what? For discharging the creditors, liabilities. This is liquidation. So liquidation is one of the important steps involved in winding up process. Winding up process. Understand? Okay, so chapter 20. Okay, sir. So 18 is defunct, 19 is sick, and 20 is winding up. So when winding up happens, right, the company is closed. Chances are it will get closed. That means dissolved. Okay, now chapter 21, unregistered companies. What? Unregistered companies. Not just registration of these unregistered companies, but also winding up. Both are covered. Sir, what do you mean by unregistered companies? Is partnership a company? The answer is yes. It's unregistered company. Is LLP a company? Yes, unregistered company. Do you think we are company? Yes, but unregistered company. Ours is an association now. I am giving company to you, you are giving me company. Company is such a common term. Please understand. Company means group of people. So we are a company. It's a different thing that we are not company under Companies Act. Okay, so we can call ourselves as unregistered companies. So there are partnership firms, there are LLPs which are called as unregistered companies. So can they register themselves as a company under Companies Act? Yes. Or they say, no, we are closing. And let's say those are big partnership firms and LLPs, then how will they close? Just like that? No, they'll have to follow certain procedure given out here. That is why they said body corporates also this law can apply. Are you getting it? So kindly understand that unregistered companies may get registered under this act or may get wound up, may get closed. Okay. Then 21A, which is recently introduced. What is it? Producer companies. Any idea about producer companies? Yes, sir. Sometime back we were talking about farming. So now let's say our friend Teja wants to start a producer company to do farming. Can he do? Yes. He says, no, I want to get into horticulture, pisciculture, handloom, handicraft business. Or maybe let's say poultry farm. Can he start? Yes. Producer company. Understand? So we have this concept of producer companies, and obviously it's there in our syllabus also, because types of companies we talk about. Okay, at least something you got to know. Producer company, come on guys. Then companies incorporated outside India. Can I say foreign company directly? No. I hope you know there are two types of companies incorporated outside India. One which is having place of business within India, and the other one do not have place of business in India. So which one they are talking about? Sir, both. Both they are talking about, isn't it? That is why they have named it as companies incorporated outside India. See, the first one, I hope you are aware, is nothing but foreign company. If incorporated outside India and has got place of business in India, it is foreign company. But if I simply say incorporated outside India, then can I call it as foreign company? No. So what's the heading of the chapter? Companies incorporated outside India. Can I change it with foreign company? No. Then what, if I am doing that, then that means I am narrowing down the scope. They're covering both, no boss. Suppose you write foreign company in place of that. That means you're only talking about those companies incorporated outside India which are having place of business in India. You're not talking about the other one. Now you may question, sir, suppose there is some company which is incorporated in Singapore and has a place of business in Hyderabad, in India. Then obviously we should regulate them because they are in India. We should regulate them, correct or not? But suppose some company incorporated in Malaysia do not have a place of business in India. Why should we regulate them? Is there any need to regulate? Okay. I'll give you a simple example. Neighbor's boy. Neighbor's boy. Yes, sir. Boy in the neighborhood. Who will regulate him? His parents, his family. Not our parents, our family, no. Why? Sir, neighbor's boy, no, sir. Acha. Suppose neighbor's boy come to your house and is playing with you. Then in that particular case, is it possible your parents, your family regulates him? Yes. Why so? Sir, why so means what? He is in our house, will regulate. So same way, company incorporated outside India and now is doing place of business or is having place of business in India, will we regulate? Yes. But if there is some company incorporated outside India doing nothing in India, will we regulate? No. Then sir, why is it written here? So please understand, maybe there may be companies incorporated outside India which do not have a place of business in India. However, they are doing fundraising from India. What? Fundraising. Raising funds. Like we can raise funds from outside India, same way others can raise funds from India. So in that scenario, shall we regulate it or not? Yes, sir, of course. That's why they have covered both. Okay. So we will talk about companies incorporated outside India, having place of business in India, or maybe doing fundraising from India. Both of it here. Then 23, government companies. I hope you remember government companies. What is it? Sir, a company in which paid up capital 51% or more than 51% of the paid up capital is held by government or governments. So we have some provision relating to it. Then next one, registration offices and fees. You know ROC office is there. Who has established ROC office? Central government. Now question comes, who gave the power to central government to establish that ROC office? You'll say, sir, Act. Act has given the power. See, we are reading not a general subject, we are reading law. So people can question the authority. They'll say, if you're doing this, if you're saying this, where is it written? Who has given the power? Understand? Tomorrow some person comes and says, I am arresting you. Will you not ask, do you have the power? Who has given you the power? Then, so obviously this is also law. We are talking about law. So if central government is doing something, parliament is doing something, some minister doing something, some administrative officer doing something, we'll question their authority. So they'll show us, boss, we have got the power here. Who gave the power? The law gave the power. Law is made by whom? Parliament. Parliament comprises of representatives of public. That means in a way public has given me the power. Correct. Next. Then, come on, companies to furnish information statistics. That means they'll ask for some info, some statistics. Company has to provide that. In which form, which manner, within what time, they will specify. Can company say, can ROC say, Tata Steels Limited, you submit this information? Can ROC say that by Section 8 companies, all the Section 8 companies need to submit this information? Yes. And if people question, where is it given? Where is the power given? They'll show this chapter. You understand? Then next, Nidhi companies, Nidhi's mutual benefit society, we call it as these days. We call it as mutual benefit society. So if someone says mutual benefit society, same as Nidhi companies, okay? Next, NCLT and NCLAT. Next, special codes, etc. Miscellaneous provisions. This is how we have 1 to 29 chapters. So is it a good law? Is it a strong law? What do you think? Yes, sir. It is a better law than your LLP or partnership. Reason? Sir, for everything we have provisions. We think of dividend, we have provision. We think of incorporation, we have provisions. We think of winding up, we have provisions. We think of foreign companies, we have provision. For everything, don't you think you have provisions here? So if you have provisions, you already have laws, you already have rules and regulation. Is it going to lead to confusion or clarity? Clarity. So if you want to start a company form of business, you know already that there are several provisions, several rules. So you are guided by them. Things become smooth, things become easy. If we don't have rules, regulations, then it lead to chaos only. Remember the first question, why law? He said chaos, theft, crime, all that. So we don't want that, then we need a strong law. So company form of business is considered to be a professional form of business. And why professional form of business? Because for everything we have provisions, rules. Here. Now, do you remember all 1 to 29? Sir, 1 to 10 though you gave clue. Sir, 11 to 16 also I gave clue. Not just 1 to 10. 11 to 16 also I gave, no? 17 rather. Registered value was next one. 18 onwards probably I need to. Correct? So what was 11? Directors, appointment, qualification. A and Q will say. 12. Board meetings, powers and restrictions. So once appointed, they need power. They need power. But those powers needs to be restricted. You can't give unlimited power. And obviously their duty will be to meet, take decisions collectively, not alone. Isn't it? Then, right, managerial person and remuneration. Then we said audit done, but still probably things are not clear. That's where inspection, inquiry, investigation, compromise, arrangement, amalgamation, prevention of oppression, mismanagement, registered valuers. So they did valuation, they got to know company is really in soup. Really in soup. So what will they do? Strike off the name. That means defunct. Chapter number 18. Or they'll get to know company has become sick. So they'll think of revival, restructuring. Next one. No sir, the situation is so worse that it is better to close. That's where winding up. 20. And Chindi clue. Chindi clue, you understand? Chindi word, no? Simply speaking, okay? Or maybe if with humor, or if I apply this logic here, maybe illogical logic. 20. 20. 0. 0 means what? Closure. Close. So company becomes 0. Company becomes 0. That means wound up. See, when you came for the first time to this building, to this classroom, this academy, do you think you have used some landmarks? Yes, sir. Near SR Nagar metro station. So we reached first SR Nagar metro station. From there we took left. Then there was some tiffin center, hotel that was mentioned to us. Then we took left. Then they said third building beside this building. So we came. Like that you'll say, no? Same way, when you have to remember something, one possibility is you apply logic. Second possibility is you apply some illogical logic also. Some landmarks also. So I am keeping this as landmark. 20. Winding up. 200. Above that immediately I'll say sick companies. And above that sick companies I'll say defunct. So I'll remember these three also. Like how I remember directors 3, same way I'll remember from 20, 19, 18. And anyway 17 I remember. 7 to 17 we talked about. Yes or no? So now I remember 1 to 20. Then we'll talk about some types of companies. So producer companies, unregistered, rather I should say unregistered companies first. Then we'll say producer companies. Then we'll say companies incorporated outside India. Then we'll say government companies. Then actually they should have said Nidhi companies. 24 should have been Nidhi. But then Nidhi is 26. Why? Night 2 o'clock effect. Maybe night 2 o'clock they were making, and you know, night 2 o'clock no one will be conscious. So unconsciously made, I guess. Otherwise, what is that? They can keep Nidhi as what? 24? No. But they have kept it as 26. Okay, so 21, unregistered. 21A, producer. 22, companies incorporate outside India. See, 22, again this can be your landmark. 22. Same to same. Steve Waugh, Ricky Ponting. You know them? Australian cricketers. Same way I talk about Elon Musk. Come on, are they same as us? Or they have 3 eyes, 4 ears? No, they're same like us, boss. Please understand, they are also human beings. We are also human beings. 2. So, Indian company, foreign company. Like that you can recall. This can be your landmark. The moment you get 3, no. 3 is government. Central government, state government, local government, local corporation. We have 3 types of elections, no, where we vote. Remember, it will become easy. So these are illogical clues or logics which can help you to remember. I don't call it as logical logic, that is illogical, but then helps us in remembering. Nothing wrong. Then 24. So that's where we say 26 first. Nidhi companies. Okay. So 21. Unregistered companies. 21A. Producer companies. 22. Companies incorporated outside India. 23. 26. Nidhi companies. Then in between 24 and 25, that is relating to administration. Administration, registration, fees, also they call information statistics. And then these 2 are relating to appeals and all. Judicial structure, NCLT, NCLAT, special courts, etc. 29, this is miscellaneous. So can you say that you remember all 1 to 29? If not 1 to 29, at least 70-80% you remember? Sir, we remember 100%. What are you saying? Oh, sorry. Then let's one final time recall all the chapters right from 1. Preliminary. 2. Incorporation and incidental matters. 3. Prospectus and allotment of securities. 4. Share and debentures. Deposits. Yeah. Charges. Management and administration, which includes general meeting. Dividend, accounts, audit. 10 done. 11. Directors appointment qualification. 12. Board meetings, powers and restrictions. 13. Managerial person and remuneration. 14. Yeah, icai. Next 15. Arrangements, compromise, arrangement, amalgamation. 16. Prevention of oppression and mismanagement. Registered valuers. 18. So if you cannot, just in case you cannot recall, then 20 winding up. 19, sick companies, and before that, defunct companies. R of ROC to strike off, so defunct. Now 21, unregistered companies. 21A, producer companies. 22, companies incorporated outside India. 23, government companies, Nidhi companies. 26, in between 24, 25, registration, administration related. And then 27, 28, NCNT, NCLAT, special courts, and 29, miscellaneous. Correct? So almost you remember all these chapters. Okay, one more clue if I have to give you. See, if you are not registered, you stay alone. 21, 1, alone. You don't register, you are left out. Think like this, boss. What is wrong in it? No, it's helping us to remember. So 1, unregistered. Now, out of these chapters, what are those chapters which you have in syllabus? Any idea? Yes, sir, we already have an idea about our syllabus. Preliminary, right? Then when they say formation and conversion, that means we have incorporation and incidental matters. We'll talk about even conversion of private company to public, public to private, OPC to private or public, isn't it? All of this here. Then we have about debentures. In our syllabus, I'm talking about our syllabus. So we have debentures. We don't have the complete share capital and debentures, only debentures. Then we have deposits fully, right? Then we don't have charges, general meeting and all, right? That was covered already in your cmainter. Cmainter, they used to say 1 to 122 plus of course directors related provisions and all. then we have dividend, then we have accounts. So did you notice the change in color? So I hope you have understood whatever color it is. I don't know what is the color. Girls will be able to say a bit better, because for us it is brown only. Light brown, dark brown, some brown, है ना? Okay, whatever. Right, you understood, that's important. Chalo. For us pink means pink. For them it is baby pink. I don't know. Then audit and auditors we have in our syllabus. Yes sir. Directors, as you could see, all this chapter 11 to chapter 16 also there in our syllabus. Correct. Directors related 3 chapters: III, arrangements, prevention of oppression, mismanagement. But then we don't have registered values. Same way. Come on, defunct companies, sick companies. Sir, wait. Sick companies you have done black. Why? Because this is removed. This is no more there in the act itself. Why? Can you guess why? Reason. Can you guess the reason why they have removed it here from here? Very good. IBC. So after the introduction of IBC, it was not needed. It was not required to be here. So they have shifted the provisions from here to insolvency and bankruptcy code. Great. Then we have winding up. No, again winding up not there. Unregistered companies to some extent. Conversion we say no. So LLP, how will it become a company? Right. So we have that coming from here. Then companies incorporated outside India. First topic itself. Conversion formation, when we say, we have this also. Then sir, miscellaneous. Miscellaneous provisions are there, though they do not specify it, but it is required, isn't it? So in a way what you can say is, sir, chapter number 8 to chapter number 16. Chapter number 8 to chapter number 16 plus some provisions coming from 1, 2, 4, 5, 22, 21, 29. Is it clear? This is your syllabus. So one thing you can smile. Why? Because you don't have the complete Companies Act. Or who knows, you will cry also. Sir, what is this? I thought we'll read fully Companies Act now, but I don't have. So don't worry, once you become CMA, you will read the whole of the law. Many of the CMAs are working in winding up also, winding up of companies. So you say, I don't know. No worries, that time you'll read. Provide, and you will understand it by yourself, provided you understand these provisions properly. What is there in your syllabus? You don't know these chapters, do you think you'll understand winding up then? Come on guys, answer. You don't know chapter 1 to 19 and you're talking about winding up. Will it make sense? No. So whatever is there in syllabus, let's read properly. Sometimes some things which are not there in syllabus directly but indirectly is of use, that also we need to read, like definitions. Even though they might say definitions are not there, but will we bother about definitions? Come on, you got to know from the definition of chartered accountant and cost accountant itself. I gave you that example. In company law, CA means in practice. Cost accountant means in practice. Isn't it? So as far as company law is concerned, we should know what these terms are. So that means definitions become important, though they may not be a part of our syllabus completely. Same way, miscellaneous provisions. OPC, small company, dormant companies, you know, right? Yes, sir. What is the penalty for them? Sir, whatever is the penalty given in the section. Suppose they violate section 65. Then what's the penalty for them? Sir, whatever is the penalty given in section 65. Yes or no? Same way, if they violate 186, what's the penalty for them? Sir, what is given in 186, 185? Whatever, respective section provides that penalty, right? You agree? You agree? I will not tell you, rather I will show you, so that you don't ask me any further question and you'll know the value of what I am saying. Okay, I'll go to this special course, etc. Right, I'll go to the last section there, 446, which you could see on your screen, I guess. Okay, then in that, if you just see factors, 446A, factors, then 446B. 446B. And if you see the heading, below they have written the heading, then they striked off anyways. What do you see there? Lesser penalties for OPC or small companies. Now I'll come to the provision. Okay. Notwithstanding anything contained in this act, overriding provision. Overriding what? All the provisions of this act. So if some other provision of this act says something which is in conflict with this, what will prevail? This will prevail. This will enjoy supremacy. Which one? 446B. If penalty is payable for non-compliance of any provisions of this act by OPC, small company, startup company, producer company, or its officer in default, or any other person in respect of such company, its officers or default or other person, as the case may be, shall be liable to a penalty which shall not be more than half, right? More than 1/2. That means half of the penalty specified. So what does this mean? Boss, whatever is the penalty specified will not be applicable for this OPC, small company, or these startup companies or producer companies. Rather, the penalty is reduced to half. So if, let's say, section 185 says 50,000 to 5 lakhs is the fine for OPC, small company, producer company, startups, what will be the fine? 25,000 to 2,50,000, 1/2. They haven't mentioned. No, I did not say. They are saying. Sir, but why are they saying like this? Why did they give lesser penalty for these companies? Obviously, these are lollipops. And when do they give lollipop? When they want to encourage someone. Do you think they want to encourage OPC, small companies, producer companies, startups? Yes, sir, obviously. We want everyone to come in company form. Even a sole proprietor, we want him to come under company form and do his business. Why so? That's a professional way of doing business. Credibility also will go up, no? And when the scale of business increases, company form is good or bad? Good, sir. When you start business, probably you'll start with sole proprietorship. Slowly you'll go to partnership. Then you'll think of business is growing, company. Directly you start with company, no? There's a concept of OPC now. Same way you'll say, no, sir, we are in unorganized sector. We are in farming, we are in horticulture. So, producer companies they brought, no? Sir, I have some innovative idea. I want to start business. It can be scalable. It is scalable rather. So, in that case, startup company you start, no? So, they want to encourage this. And how will they encourage? By giving lollipops. What do you mean by lollipops? Exemptions, privileges, lesser penalties. These are lollipops, no guys. You don't write exam literally lollipop, huh? So kindly understand that is nothing but exemption privilege. So now please tell me, is there any relevance of this section 446B? Of course. You will be reading sections, you will be coming across penalty. You should know if these companies are there, that penalty will get reduced to half. You will say, no, sir, it's not in our syllabus, we will not read. Arey Durmargudu. Few things may not be in your syllabus, but still you are supposed to read. No, so that you understand those provisions which are there in your syllabus properly. Clear to you? Same way you will say, sir, why 29? 447 is penalty for fraud, no? So will you ignore? Then same way 450, punishment, where no specific penalty or punishment is provided, which we call it as general penalty clause for the act. Becomes important or not? So don't think we're doing time pass here. We don't have so much of time to do time pass. Okay, we are trying to study in such a way that we should leave no stone unturned, as they say. We want to cover everything so that we are ready for the examination. Okay, so did you get this idea? That some provisions which are not there in our syllabus also we might refer, we might read, because that will help us understand the provisions in syllabus properly. Clear? Great. So 1 to 29 chapters you got to know. Acha, one thing. What is this? Section 270 to 365. For which chapter? Winding up. Oh my God. Almost 100 sections for winding up. Just understand the importance. Just understand how difficult it will be to close the company. It's like CA, CMA, Professional courses, entry is easy. Exit, CMA foundation, what's the pass percentage? Right? Yeah, 90, 85, 90 easily. Even sometimes maybe 95 also. And what about cmainter? What about CMA final? So we know entry, no problem. But exit, not a problem, but challenging. Same way, if you understand, company, if you want to incorporate, they will be welcoming you with folded hands. Please come. And closure, follow these many provisions. The point is, this again creates that confidence of people in companies. First, if you say yours is a company registered under Companies Act, don't you think people will trust you more? Come on. Yes. So don't you think people would like to transact, associate with you? Yes. The company form of business has got that power. You go for some shopping or you purchase some product and they say, you ask some discount, they say, it's our company's policy, we don't give it. Oh, company. Oh, sorry. Whereas some small shop and all, kaisa nahi dete, ichchendi, ichcheshei, bolte na. You might say that, but you need to understand what point I am trying to bring out here is company form of business will have that credibility and trust. People will believe company. Even suppose now you go to a bank and ask for loan, and let's say a company goes, a partnership firm goes, where do you think is a better chance of getting loan? Company. Than the partnership firm. Simple logic. Because it's highly regulated. It's not like anyone can walk in and anyone can walk out. Okay. Next. Is there any relevance of writing section 1 to 2? Simply I can write 1 and 2, no? Chapter 1. Preliminary. Section 1 and section 2 I can write. My friend at the end. Last bench. Brown shirt. Sir. Sir. Here. Slightly move, no? I cannot see you. Yeah. So is there any relevance of 1 to 2? Yes. Can there be 1A in future? 1B in future? Yes. So please understand, that's where we don't write 1 and 2. Right now it is 1 and 2, I know. But then later, who knows, they may change. The best thing would be always to write 1 to 2, the way they have written in the Bare Act. Same way I have written. I have not changed it because there is relevance. Clear? Now you might say, sir, these are chapters. Are there no parts? There are parts as well, but not in all chapters. Okay. When you see this chapter 3, you will find 2 parts are there. That means sub-chapters. Subgrouping. See, chapter is a group. There are subgroups also in this. Same way, if you come across winding up, you will find 4 parts are there. Then you see this unregistered companies, 2 parts are there. Then producer companies, several parts are there. So only these 4 chapters or 5. How many? 4, no? Yeah, 4. First I said chapter 3 and then I said chapter 20, 21, 21A. These chapters you will find has got parts. Otherwise all other chapters directly sections. Okay. Sir, we are not bothered about all those things. We don't have any work. Chalo, now let's talk about schedules. 1 to 7 schedules. What are we doing? Taking overview of Companies Act. We're discussing some basics. We're discussing some overview also, no? It's important for us to understand this or not. See, let's say opposite side there is a building. Foundation is laid. Foundation is laid. Now they've constructed floors, roof. Not any walls or no electric wiring done, nothing. Only floors. Have you seen that type of building? Yes, obviously you'll come across that. Now you take it on lease. That building, let's say you take it on lease. And you tell them, give us as it is. First possibility. Give us as it is. Why? Sir, we will construct according to our requirement. Second possibility, construct walls and give me. Third possibility, not walls, because we want glass. So put glass and give us. No, we want even electric wiring. We want false ceiling. No, we want complete interiors to be done and then give. Don't you think you can specify like this? Same way, now what are we doing? We are building the foundation. Once the foundation is laid, later on when we start studying the topic, what will we do? Some topic will get into the depth, meaning we'll get to the interiors level. And some topic not to the depth. Why? They're not required. So why should we get into the depth of it? So that we can decide or not. But foundation has to be strong. Later on that work can be done as per the requirement, but foundation itself is weak, the building will collapse. How much beautiful interiors they get it done is of no use. Same way, I get in 2 directors topic. That's my favorite also for your kind information. 11, 12, 13. I've been teaching CA final since years. So obviously I have grip, I have interest. Maza aayega na, I'm myself a chartered accountant. So shall I jump to that or lay foundation first? Lay a foundation so that these gaps are not there. Then we'll construct according to the need. And then as I've told you, probably my pace will also go up and you will say, it's okay sir, the pace is decent, good, because we are able to follow. And why we are able to follow? Because we are able to understand these things. Correct? So please have patience and please understand what I'm doing is doing with some reason. Okay? So 1 to 7 schedules are there, as you could see. First one, the table A to E deals with MOA and table F to J deals with AOA. So you know that model proforma, model MOA is there in table A to E. Sir, why these many tables? Because depends on type of company. If it is company limited by shares, where is the model MOA given? Okay, table A. And then if company limited by guarantee without shares, table B. Company with shares, then C. Unlimited guaranteed without shares, then D. Unlimited guaranteed company with shares, then E. Okay, this way they have given model MOA in schedule. Now F to J, can you guess? Sir, model AOA, articles. Acha, MOA means what? Yes or no? What can the company do? What the company cannot do? Basically, predominantly, MOA is about object clause, whereas articles is about how do you do it? Correct? Rules, regulation, bylaws. Okay. So, can you guess table F? Yes, sir. Model articles for company limited by shares. Yes or no, guys? Then table G. Can you guess? Company limited by guarantee. That is where it is wrong. Those who said with are correct. First it is with, then without. Then unlimited guaranteed company, you will say without shares, but it is with first, without later. Night 2 o'clock effect. Again, they can maintain the same sequence, no boss. If they have said for MOA without first, here also it can be. Then anyways, and you're not writing anything now, you have stopped completely. That's not correct. No, I'm not talking about you, but I'm talking about a few students who are not writing at all. Which chapters are there in syllabus? So at least you can write those numbers. Same way, now you're getting to know schedules by 1 to 7. 1 is about MOA, AOA, depends on which type of company it is. Hai? Correct, guys? Acha, is this schedule 1 going to matter to us? Yes, sir. Formation, conversion. So we may talk about MOA and AOA. Next, schedule 2, rates of depreciation. Sir, already we know this. Is it going to matter to us here in paper 13, corporate and economic laws? No, sir. Why? Sir, we are not in accounts class, no? So we don't need this rates of depreciation, so we will not refer. Then schedule 3, financial statements, the format of financial statements. Do we need here? No, sir. Maybe in accounts, maybe in audit we need, but not in this paper. Correct? Then schedule 4, independent directors. Yes, sir. Absolutely. We'll talk about independent directors. 5, Definitely yes, sir. Acha. Schedule 4 we will read in which chapter? What do you think? Good. Directors. In directors, 3 chapters are there. Which chapter? Very, very good. 11. Because there we said directors appointment and qualification. So obviously it has to come there. And then what about the next one? That is schedule number 5. Obviously 13th chapter. The name itself is same. Appointment and remuneration of managerial personnel. Start thinking that also. I've told you, you should know where to search. That's why this thinking is required. Next, 6. Infrastructure activities. Are we bothered about this? No. However, we may still refer if required when they say infrastructure activity. I hope you have heard of preference shares needs to be redeemed within maximum period of 20 years. But if they miss out? If they miss out? Sir, how can they miss out? But suppose that's a company in infrastructure activity. I hope they are given an extension, or they may be given an extension of 10 years more. That means 30 years within which they may redeem. So that time, don't you think it is important for us to know infrastructure activities? Like that, if we come across companies with infrastructure activities, shall we ignore it? And for us, infrastructure means only construction and real estate. But for your information, even power comes under infrastructure, water comes under infrastructure. So that's why it is important for us. So if at all we come across, then we will see. I will not tell you now. Okay. Then next, schedule 7, CSR. Do we have? Obviously, sir. Section 135, chapter 9, plus we know 3rd module in corporate law, corporate governance, sustainability, social responsibility. Obviously, that's there. So how many are there, or how many are useful for us? Come on. 1, 4, 5, 6, sir, you did not say. 7. So out of 1 to 7, we don't have everything in syllabus. Correct? Clear to you, guys? MOA, what? AOA, how? Sir, shall we make a note of this? No need. No. 1 minute. Suppose someone asks you, where is model articles given? Suppose someone is asking you, where is the model articles? Where is it given? Sir, Companies Act will say. Are in Companies Act, where is it given? Sir, Schedule 1 we will say. In Schedule 1, where is it given? Will you say table F to J? No. Then what will you say? See, you'll say Companies Act. You'll say Schedule 1. Then you'll say table. But which table? For your kind information, you will say table F. Why? Because generally, the type of companies which we have is company limited by shares. You agree with me? Company limited by shares. Predominantly, that's the type of companies we have. So if the person who's asking you this question doesn't specify which type of company he's talking about, that means it is company limited by shares. And on that basis, we'll say it is table F. Here, same way, model MOA. Model MOA, table A. Table A. No, table I also. No, table J also. Table C. Array, you specify the type of company. No, then I will mention. You don't specify type of company, I'll simply say table A for model MOA, table F for model AOA. And those who don't believe me, see some statistics. This statistics is taken from this website mcacdm.nic.in. There is Ministry of Corporate Affairs website only. CDM, Corporate Data Management, the source for this statistics. So as on this date, 3rd of June 2026, how many total companies have been registered till now? 31 lakhs plus. 31 lakh plus, I'll say. Out of which, how many are active? 21 lakh plus. Right? 31 lakh plus is what is incorporated till date. Till date in the sense 3rd of June. Okay, 3rd of June. But 21.17, that is 21 lakh plus, is what is active. Now just see the bar graph which is here. What is it? Company limited by shares. Out of those 21 lakh plus companies, if you just see, 20.97 lakh companies are company limited by shares. And how many companies are limited by guarantee? Some 20,000. And how many are unlimited guaranteed companies? Only 300 plus. So out of some 21 lakh plus active companies, 20.97, please understand, around 21 lakh companies are company limited by shares. Hardly limited guarantees and unlimited, so you can understand, hardly 307. So this statistics, don't you think, is supporting my point where I said, if someone asks you model AOA, what will you say? Table F. Model MOA, what will you say? Here. Some more eye openers for you. Normally, when someone says company, what do you think of? Listed company or unlisted company? Unlisted you need to think of. If you are saying no, listed, then see this statistic. Again, as on the same date, 3rd June 2026. How many companies are listed out of those 21.17 active companies? 7346. Unlisted are 21.1. And these listed companies, I hope you are aware, will be regulated by even SEBI. Listed companies are all regulated by SEBI. Then you might say, sir, what about government companies? So if you just see government company, non-government company, okay, you just observe. Sir, union government, that means central government is a member, right? State government is a member. Then non-government company, the number. So generally companies are non-government, that means private sector. Public sector means government. Private sector means non-government. Reliance Industries Limited. So public sector? No, sir. Private sector company. It's not a private company. It's a private sector company. It's a public company, we know, but it's not public sector company. Public sector means government. PSU. Government company, PSU, public sector companies. HAL, PSU, BHEL, PSU. So we know there are some government companies. So if you see the number, you will find state government 1843 and union government is 661. So put together some 2500 companies are only government companies. Remaining are all non-government companies. And then this chart will help you understand that the number of companies year by year are increasing. So if you just see 25-26 financial year, how many companies got incorporated? 2,47,000 some change. And now 26-27 not yet completed. It's only till 3rd of June. So April, May, hardly 2-3 days of June. Already 46,000 companies are incorporated. So number of companies are growing. So please understand, you, the professionals, are going to service or provide service to whom? Companies, businesses, and businesses mainly companies. So number of companies are growing up. So is it good or bad for you? So if someone says CMAs do not have future, CS do not have future, company secretaries do not have future, show them this statistic. Say, Durmargudu, please have a look. Business is growing, boss. India is growing. And not just because of one government. Don't think only this government, current government has led to this. Previous governments also have worked hard, no? That's why we could see. But it's politics where Modi will say, no, I only did everything. Right? Sonia Gandhi will say, no, our government only did everything. Because it is the cumulative effort of everyone. Clear till here? Now some doctrine we'll talk about. Okay, what are we discussing? What are we into? Basics and overview of company law. Okay, so we have seen schedules, we have seen the chapters which we have in our syllabus also, and completely we know where we have to proceed. Now doctrine. Heard of the word doctrine? Yes, sir. What do you mean by doctrine? Legal principle having universal acceptability, though may not be a law. Legal principle having universal acceptability, meaning people are accepting it, everyone is accepting it, or has accepted it. That's why it's called as doctrine, though it is not a law still. Okay, sir. So, sir, who gives this legal principle? Who gives this legal principle? Obviously, courts. And when I say courts, am I talking only about High Court, Supreme Court? No, quasi-judicial bodies as well. Correct? We're talking about even quasi-judicial bodies. So please understand that doctrines are given by the judges, the courts, the legal principles, which has universal acceptable. So when we talk about company law, I hope you know we talk about doctrine of ultra-virus, doctrine of indoor management, doctrine of constructive notice. So I want you to revise that. I want you to recall that. First, doctrine of constructive notice. You remember? Doctrine of constructive notice. See, any outsider who's dealing with the company, any outsider who's dealing, any stranger who's dealing with the company has to read MOA, AOA. Obviously, after reading, he has to understand. And then verify, ensure whatever is written there is followed. Correct? That means if he doesn't ensure, doesn't verify, then he will not get protection. If something goes wrong, will they give protection? They'll say, no, it's your fault. You should have, verified or ensured. Isn't it, guys? And do you think, as a stranger, as an outsider, it is possible practically that you check everything? Suppose in the articles it is written, for taking loan, they should get a special resolution passed in the general meeting. Do you think it's possible for you to ensure all of that every time? No. That's why this doctrine has become impractical, redundant, no? Come on, guys. And we have the next doctrine, indoor management. Anyways, first let's complete this. So we said any outsider transacting with company shall read and understand MOA and then ensure, verify whatever is written is followed. Then only he'll get protection, otherwise he'll not get protection. So here actually company gets protection. So this I am saying is practically not possible. That's why we were in need of some other doctrine, and thereby we got indoor management. Right. Do you remember the landmark judgment for constructive notice? Kotala Venkataswamy versus C. Ramamurthy. Anyways, not required also. But at least you should remember the landmark judgment for indoor management. Landmark judgment for indoor management. Do you remember by any chance? Royal British Bank versus Tarkan. Royal British Bank versus Tarkan. Okay, that is the landmark judgment. Anyways, so what does this indoor management says? It says, as an outsider, you should read, you should understand MOA, AOA, and then presume, assume. No need to verify, ensure. Boss, as an outsider, how will you ensure, boss? So you just assume if it is written, it might have been followed. If I give you some homework, I'll assume you have done it. Understand? Why? Because practically it is not possible for me to check each and every student's homework. Maybe one or two I may, but everyone's not possible. Please understand. So that's what they're saying here, that indoor management, okay, outsider again has to transact with the company only after reading MOA and AOA, and then he can presume whatever is written has been followed. So this doctrine gives protection to outsider. However, there are certain exceptions. So what will happen in those exceptional cases? Company will get protection. So if you remember exceptions by any chance, sir, some stranger, some outsider is there who has not read MOA and AOA, not consulted MOA and AOA, thinking that anyways indoor management is there, no re, why should I bother, I will get protection. They said no. Here who will get protection? Company. Why? because you didn't read. Okay, second possibility. He read and he knows there is some deviation. There is some deviation, there is some irregularity. But he ignored it. He said, why should I bother? Anyways, I'm getting protection, no? Then what does law says? No, you will not get protection in this. Company will get. Understand? He got some doubt. He should have done some inquiry, some questioning. He said, why should I do it? Why? Because indoor management is there. Or he inquired. Still, actually there was some doubt, but he didn't do further inquiry. Again, do you think he will get protection? Come on, guys. No. You know, let the buyer beware, we say. Same way here, we'll say, let the outsider beware. Boss, you don't close your eyes and transact with the company. At least open your eyes, read the MOA and AOA. If you're getting some doubts, ask questions. Don't do that and you say protection, protection, protection. No protection. No. Who will get protection? Company will get protection then. That's what they're trying to say. So which one is practically possible and relevant today? Indoor management. Is it clear to you? All of you? So next time I'll be using this word indoor management, constructive notice. So you should not ask me then. Today only we have completed it. Okay? Right. So next, one more, which we said, ultra virus. All of us know this. Ultra means beyond. Virus means parts. So beyond the parts of the company, because we're talking about in context of company law. So obviously ultra virus the company. And where are the parts of the company given? Very good. Memorandum. And memorandum, where is it given? Object clause, as your friend has already mentioned. So when we say ultra virus the company, ultra virus the MOA, ultra virus the object clause, is it all one and the same? Yes, sir. Now please tell me, can it be ratified? If they're doing something beyond their parts, if company is doing something beyond their parts, can it be ratified? Can it be ratified? No, boss. It cannot be ratified even by the whole body of shareholders. Please understand this. Arey boss, an ice cream manufacturing company now starts manufacturing crackers. In MO it is written ice cream manufacturing. They started manufacturing crackers. Is this correct? Do you think then you will take the MOA of that company seriously? No. You'll say they write something, they do something else only. So having written something in MOA, they have to abide by it. They have to follow it. Isn't it? If they don't do it, even members cannot ratify. Acha, what is the meaning of ratifying? Subsequent approval. Not approval, subsequent approval. Okay, what is ratification? Subsequent approval. Now let's say some student enters the class now. Some student enters the class now. What do you think he's supposed to do? Sir, seek your permission. Because he's coming not late, very late. Right? Last half an hour he wants to attend. So obviously it is not late, it is very late. So basic expectation or basic etiquette says he should seek my permission and then enter. Let's say he did not do that. He came here and he was about to sit. Then friends indicated, Re Durmargudu, you don't know this Durmargudu? Now he will shout. He will scold. So then he realized and he's trying to turn to seek my permission. And I say, no problem, sit. What does this mean? Approval or ratification? Ratification. This is not approval. Approval would have been when he stands there and seek my permission and then enter. That is approval. He came already, then he's about to turn and go back and seek. That is, right? Yeah, so I say no problem, sit. That means ratification. So I can spell it like this. When a person does something, and that to which person? Who doesn't have the authority. When a person who doesn't have the authority does something, and later on the person who has the authority confirms, approves, then it is said to be ratified. So the student doesn't have the authority to enter. Yes or no? Enters, and the person who has the authority says, okay, confirms. That means I have ratified his act. No. Same way in company, MOA, they say something and they are doing something else. Then who has the power to ratify? You'll say, sir, members, because their money, they are the owners. They said, boss, members, owners cannot do anything. Because if we start allowing this, then it will become a joke. They'll write one thing in MOA, do another thing. How do you expect that to be, trusted by the outsiders or strangers? No. So they said, no ratification here, boss. Next, ultra vires the articles. Come on, answer. Sir, can be ratified by passing special resolution. That means members, because it's about how is okay. But then okay doesn't mean that without approval. Huh? Members have to approve. That too, special resolution. And when do we say special resolution is passed? More than 3/4 of the members give approval. What about exactly equal to 3/4? Then also, special resolution is 3/4 or more than 3/4. Okay, and then what about ultra vires the directors? Ultra vires the directors. Directors are going beyond their powers. Come on, guys, answer. If directors are going beyond their powers, they're acting beyond the power. Some director has been given the power to sign check worth 2 lakhs or below 2 lakhs. He has signed a check worth 5 lakhs. Ultra vires, that means beyond his powers he has gone. Can it be ratified? Yes. Ordinary resolution. No need of special. Ordinary resolution is enough. So ultra vires the directors, OR is needed for ratification. Ultra vires the articles, SR is needed. But if you say ultra vires the MOA, ultra vires the company, even whole body of shareholders cannot help. Whole body meaning 100% also of the members agree, that's not going to help. Okay. So what does company law says? What is SR? Sir, votes in SR is special resolution. Nijanga. SR is where they say votes in favor greater than or equal to 3 times vote against. Greater than or equal to 3 times vote against. So if 5 votes are against, how many votes in favor is needed so that we can say SR is passed? Minimum 15. 3 kadu. 5 against. So minimum needed in favor is 15. So 15, 16 in favor and 5 against, then we can say SR passed. Or we may say like this also. Sir, votes in favor is equals to 3/4 of total votes. Correct? No? Total votes. Suppose I say 40 votes are there totally. Then 3/4 into 40. That means 10. So minimum vote. Anna? Yes or no? What yes? Whatever I say yes only. 30 no. I said 10, you are saying yes. Out of 40, if 10 votes are in favor, how can you say special resolution passed? 30 has to vote in favor or more than 30. Then we say special resolution passed. So either ways you can say. You can say votes in favor should be 3 times or more than 3 times of vote against. Or you may say vote in favor should be 3/4 or 75% or more than that of total votes. Anyways, it leads to the same thing. And when it comes to OR, come on, what is OR? Thank you. Votes in favor greater than vote against. No equal to here. Because if I say votes in favor equal to vote against, that leads to deadlock. Deadlock. Dead end, we say no. Votes in favor, votes against, same. Then how do we take a decision? Very good. Casting, right? We say casting vote, not casting. Casting vote to be exercised by the chairperson, chairman. Shall we have class tomorrow? So half says yes, half says no. What is there? Deadlock. So also, I also participate in that voting. Let's say half yes, half no. Deadlock. Now, I'll be the chairperson. I'm the chairperson, so I'll be the chairperson who will be casting second time the vote. That is casting vote. So that means decisive vote will be with me. So I'll say yes, there will be class. Finished. Class there. This is how it works. See, company law has given answer for everything. Hardly you'll find gray areas. So that means number of cases in court, litigation will be lesser, no? Because solution is there for everything in law. Why do we need to go to court? If solution is not there in law, then we go to court. Simple. Okay? Achha. Whenever we say SR, remember, it's only general meeting. It's only general meeting. That means, sir, board meeting, we don't have SR. No. Never you'll find special resolution in board meeting. Never. అది ఓకే ఆంటీ, కానీ నేను చెప్పేది ఎస్ఆర్ ఇన్ బోర్డ్ మీటింగ్. నో, యూ విల్ నాట్ కమ్ అక్రాస్. ఓకే, there is SR only in general meeting. Achha, what about OR? Sir, both general meeting also will find, board meeting also will find. But in board meeting, when there is OR, we don't call it as OR in board meeting. We say board resolution. So when OR is written, that means it's OR in general meeting. But not like OR cannot be there in board meeting. Board meeting OR will be there, and that is called as board resolution. But there's no concept of special resolution. I'm repeating again in board meeting. So do you know what is unanimous resolution? 100% what? Okay. Votes in favor 100%. Come on. Oh, he's saying all votes are in favor. That's where unanimous resolution. Yes or no? But here slightly I'll improve. You're right. Your answer is correct. So when we say all members who are entitled to vote, those who have come to the meeting and are entitled to vote in favor, then we say unanimous resolution. Suppose 20 have come. 2 are not entitled to vote, so leave them. 18 are there, no? All those 18, if they vote in favor, that means unanimous resolution passed. So this concept of unanimous resolution you will find only in board meetings, not in general meetings. General meetings you will not find unanimous resolution, but you will find special resolution. In board meeting you will not find special resolution, but you may find unanimous resolution. Did you understand what I am saying? Yes sir, better than you. Yes sir. General meeting we may find OR, we may find SR, but will we find unanimous resolution? No. In board meeting will we find OR? Yes, that itself is nothing but board resolution. Will we find SR? No. Will we find unanimous resolution? Yes, we may find, but not every section. If I correctly remember, 186 and 203 you will find unanimous board resolution. Okay, be clear with it. What do you mean by resolution, by the way? Resolving, deciding, decision, New Year's resolution. Meaning I have taken a decision on the New Year Eve, I'll not be smoking, I'll be going to gym, correct? So like that we take some decisions, we resolve, isn't it? Okay sir, understood. Fine. Come on guys. Now few small fundamentals we'll try to discuss. Till here any questions? No, all of you are able to follow me? Yes guys, please answer. How about my YouTube live students? At least those who have messaged, please convey whether you are able to follow. Yes, I'm waiting for you guys. I know whether people are there or not. Yes, Ishwar. Thank you. Subramaniam, thank you. Thanks for responding. See, we can see here how many viewers are there. So you can't say no one is there and all. Okay, I have sense. So if you think you are CMA final, let me tell you, I am also chartered accountant. Isn't it? I did not wanted to say this, but you're compelling me to say this. And it's my job when someone is attending, maybe online, but then it's my duty to include them as well. Right? Not just bother about you, but bother about them as well. With that idea, I've asked. I don't have a problem with humor, boss, but these things not right. These things not correct. Either you're making fun of me, you're making fun of them, or making fun of class subject, which is not at all good. Fun is good. Making fun of someone is not good. Please understand this. Understand, it will be all good. We'll have a smooth journey. Else, obviously, you'll see my other side also, because I'll be forced to. Correct? No? Chalo. So let's talk about other fundamentals. Company form in a nutshell. Someone asked, what is company? Same way, two-tier management structure. Have you heard of it? Yes, sir. Just now we have heard that sometimes even general meeting, OR, SR, sometimes members also will approve. Yes or no? Appellate structure, administrative structure. Do you know all these things? So let's try to recall, or let's try to understand this. First, company form in a nutshell. So sir, some shareholders are there who will put in money. Then some directors are there who will manage the company. And then someone will come and do the verification. That means audit. That is an auditor, in short. In a nutshell, I'm saying there are shareholders, board of directors, auditor. Number of shareholders. See, where is Murthy? Now, where is Sridhar? Where is Sundar? Subhashini? So there are many shareholders might be there in listed company, right? Yes, sir. Board of directors. So you can understand. I hope you are aware, because you have read this in your intermediate as well. How many directors can be maximum there? Very, very good. 15. Minimum number of directors. Very good. 1, 2, 3. 1 in OPC, 2 in private company, 3 in public company. This is minimum number, whereas maximum is same for all. Correct? Whether it is private company, OPC or public company, maximum number of directors 15. Why? Why maximum 15? If they want to have 50, what's wrong in it? Decision making will not be possible, sir. They'll be keep fighting only. More the number of partners, more the number of decision makers, more the number of directors will create problem only. Just imagine in your family also 7 people take decisions. Will it be good? No. 1 or 2 enough. Maybe your parents, maybe your grandparents, depending on the situation. Kindly understand, board of directors limited number. See, there is reason for everything if you understand. Next, auditor. Auditors also can be there, because you know joint audit concept also. Anna? Good. So this is in a nutshell. Now tell me partnership form of business in a nutshell. Sir, partners only put in money. Then partners only manage it, but may not be all the partners. And do you think their audit is compulsory? No, sir. There's nothing called a statutory audit in partnership form. There's a statutory audit in case of. Acha. When I am talking about auditor, which audit I am talking about? Internal audit here, cost audit here. Cost audit also statutory audit? No. That is there because of statute. Which statute? Companies Act. So you need to understand that we will say, sir, audit of financial statement. And obviously he is external auditor, not internal auditor. That means independent, sir. The audit are of different kinds, as you know. But when we don't specify any particular kind, it means They're talking about financial statements, audit of financial statements. Okay, when nothing is specified, guys, so what will you think of audit? You'll think of environmental audit, you'll think of concurrent audit. Come on, no, sir, we'll think of external audit, that to audit of financial statements done by an independent professional, that is a chartered accountant. Am I right? Sir, why this picture? Do you think these persons who are board of directors can also be shareholders? Yes. Can I be shareholder and director of the same company? Why not? Mukku bhai, Mukesh Ambani, is a shareholder as well as director, no? Yes, sir, of course, that's possible. But is it possible shareholder is auditor? No, sir, that's not possible. Director is auditor, sir, that will to sound funny. Because director will do work and director only will review his work. Will it make sense? No. This is also principle of natural justice. No one can judge his own case. Please understand. Okay. So I believe you have understood why I have written like this. Now let's talk about two-tier management structure. Someone will say two-tier. Your wish. Two-tier management structure, which is also called as oligarchic management. Oligarchic management. Any idea? No? An idea can change your life. Okay. So guys, please understand, sometimes we say decisions are taken by board of directors. Sometimes we say decisions are taken not by board of directors but by members of the company. And sometimes we say board has to do it but then take the approval from members. Heard of this? Sometimes board will do it, boss. Sometimes board has to go to members for approval. Sometimes members only will do it. Correct or not? Yes, sir. So, suppose company has to decide discount policy. Who will decide? Board of directors. Is there a need for members to interfere? No. Company has to decide its purchase policy. Board of directors. Promotion policy for the employees. Board of directors. Sir, employee stock option they want to give. So, sir, board has to propose, but then ultimately who has to approve? Members. So, don't you think members will also have role sometimes? Dividend proposed by board of directors, approved by members. And stop saying the word shareholders if possible. Start using the word members. Reason? Every company may not have shareholders, but every company will have members. Sir, how is it possible? Company limited by guarantee without share capital. Unlimited guaranteed company without share capital. So we know there can be companies without share capital. So obviously in those cases, come on guys, we will not have shareholders but we will have members. So best or better term is member than shareholder. I know we are used to it. People use it interchangeably. We also do. But if possible, try to avoid and say members. Okay. So can I conclude like this, that when it comes to routine matters, board of directors will decide. When it comes to non-routine matters, members will participate in the decision making. Come on guys. Are routine decisions, do you think you will involve members? Members will say, you Durmargudus, what are you doing? We have appointed you for what purpose? Isn't it? So kindly understand, when it comes to routine decisions, board of directors alone. Non-routine, that is where members will come. Members will come. Maybe members with directors or simply members will say. Okay. Company wants to go for buyback. Routine matter, non-routine matter? Non-routine. So board has to propose, ultimately members have to approve. Sir, up to a particular limit, board only? Yes. But beyond a limit, members. Simple logic I am giving you. If you are confused any time, this logic will help you. Company wants to go for amalgamation. Sir, members they have to ask, because this is non-routine matter. They can't do it by themselves. Company wants to recruit some employee. Board will decide. Why do we need members' involvement there? Isn't it, guys? So kindly understand, simple clue is routine, non-routine matter. Okay. Acha. I again repeat, sometimes members alone will decide, meaning no need of board resolution, only resolution in general meeting. Whereas when I say board with members, that means board resolution plus resolution in general meeting. And when I am talking about board alone, obviously only board resolution. Clear? Managerial remuneration. Members, very good. Sir, how can management themselves decide their remuneration? Do you think I can decide my remuneration here? No, sir. How can you decide? You'll join some company, you'll take up some work from client, you'll only decide? No, sir. Maybe, sir, in practice, I will decide what will be the fees I charge. But in employment, you can't decide your salary. You understand? So simple logic. There you'll have members. There you'll have simply members. So we'll talk about it. This clue will help you a lot. Acha. Let's say members are involved. Now members are involved and I said resolution in general meeting. Here also I said resolution in general meeting, here also. Which resolution? OR, SR? That depends on the matter. If matter is not that important, OR is enough. Matter is important, critical, then SR. OR means simple majority. No? Just now we said votes in favor greater than vote against. So that means more than 50%. And what about SR? Sir, 3/4 or votes in favor should be 3 times of vote against. So special majority needed, no? Acha. Can I say other also here? Sometime they may say 90% has to give approval. 95 has to give approval. That means that becomes further special. Yeah, there are instances where they say not OR, not SR, but rather 90% of members have to give approval, 95% has to approve. That also is the situation. If you remember, you have read this already, general meetings topic. And in case you have not read, left it in choice, now anyways, wherever it comes, I will help you. So this is the clue which you should remember. Routine, non-routine matter, and non-routine members when involved, maybe OR, maybe SR, depends upon the criticality. If critical, then SR. If not critical, then OR. And if further critical, maybe it will be some other type like 90-95%. Generally it is 90-95. Never 100% you'll find. Except you'll say, sir, one item which we saw. Yeah, but then hardly there. Okay, that's why we are saying unanimous you'll not find. Okay. Chalo. Now let's go to the next one. Appellate structure. Appellate. Do you think I'm wasting your time by any means? No, right? You are able to follow. You're able to understand the relevance of these things. Now, appellate structure under Companies Act. That means, sir, appeal structure, judicial structure. We're discussing that now. Already we have an idea about it. Come on, tell me. NCLT, NCLAT, Supreme Court. And for speedy trial, special courts. Okay? NCLT, but you're not happy, go to NCLAT. Not happy, go to Supreme Court. And for speedy trial, we have special courts. Which chapter? Special courts, which chapter? 28. Do we have in syllabus? No. NCLT, NCLAT, sir, above that, 27. Do we have in syllabus? No. So, though you are interested to read about this, I'm sorry, will not be reading about it. Meaning, I'll not be reading about NCLT, NCLAT. But when we talk about application to be filed with NCLT, all of that we'll discuss, like compromise arrangement. Do you think company should do compromise with the party, with the creditor, with the financial creditor, without involving tribunal? Suppose some company wants to do some compromise. With whom? Creditors. Sir, why will they do? Obviously, they are not having money. The business is not doing good. So, they want to do some settlement, some compromise with their financial creditors. So, they'll prepare some scheme, some draft. Yes or no? Do you think that this should be approved by NCLT? Why? Sir, if they get it approved by NCLT, in future they won't face any problem. But if they don't get it approved by NCLT, who knows, financial creditors who are accepting later on will say, no, when did we say, when did we agree? See, this is also a trick. Simple example I'll give you. Ganesh has to give me rupees 1000. Okay, Ganesh has to give how much? 1000 rupees to me. He says, sir, sorry, I have to pay examination fees, this, that and all. I don't have. So I can give you only 200. Let's finish the matter, sir. Take 200 and finish it, sir, please. I say, okay. He gives me 200. I take it. Then tomorrow, when we meet, I say, Babu, 800 rupees. He says, sir, yesterday only you agreed for 200 against 1000. When did I agree? So don't you think it is a trick played by me, because I thought first let me get what he is giving, then I'll again ask the remaining amount. People do this mischief or not, tell me guys. But let's say when we are doing this, or when we wanted to do this, he gets the court order and then gives me 200. Tomorrow can I ask remaining 800? No. So don't you think NCLT involvement is required there? Yes. So please understand one more thing. Sometimes prevention is better than cure. Rather, every time we'll say that, but sometimes. So don't think NCLT means only for grievances we will go. We have some grievances. Grievances, you understand? No? Complaints. We have complaint, then only we'll go to NCLT. No, sir. In order to stop any mischief, prevent any mischief or wrongdoing, also we may go to NCLT. That is also going to be there. Clear? Understood? No? Logically, if you read, no, you'll find every law is interesting. And you'll understand for everything we have reason. And automatically when you know the reason, you'll remember. If not 100%, 50%, 60%. Sir, how do we make that 50, 60% to 100? Revisions. Multiple revisions. Some student was saying, sir, we'll forget now, we study. What should I say? Durmargudu only, no? Arey boss, just because you think you'll forget, you will not study now. Just because you think that you'll have to pay income tax if you earn income, you'll not earn. And see, it's all mindset. I've told you day one itself. If you think you'll forget, you will forget. If you think, no, I can remember, I'm able to understand, why will I not remember? Maybe there will be some dust, which I'll clear it. How? By revision. Automatically I'll remember. Why do you think I will not remember, boss? I have confidence. Whichever subject you're reading now, I will remember it, not just till exam, for my life. And you will be. Believe me, you will be. Do you think I've revised every subject, whatever I have read in my CA days? Again and again I've revised? No. But do you think I remember most of it? Yes. How come? Mindset I've prepared like that. I remember. Something I don't know, I'll refer, but I remember. I've understood. I'll remember. Why will I not be? In school, whatever you have read, you have forgotten completely. No. Then, so please don't have that negative mindset, guys. Next. Generally, the appellate structure when we talk about, I hope you know, we talk about judicial magistrates, session court, district court, city court, high court, supreme court. So that I have written just to help you understand. Okay. Different laws will have different appellate structure. Generally, this is the one. Sir, below also we have like judicial magistrate of second class. Okay. Sir, Gram Panchayat, Khaf, Munsifs. Like that we have below also. But we don't need it. That's why we are not talking about it. Friendship later. Okay. In class, student. Come back. I'm talking to you guys. So, there is some more layers, but we don't talk about it. Reason, we don't need it. Okay. Right. Then last one for today. Administrative structure. Under Companies Act. I'm not talking about country as a whole. Others will say, sir, there is central government, then state government, then there is some federal, some power with center, some power with state. State can decide. I'm not talking about that administration. I'm talking about under Companies Act. Come on, tell me. Come on, under Companies Act, administrative structure, MCA, ROC, good. RD, regional director, director general of corporate affairs, DGCA. Don't know. Official liquidator. Like how in income tax, you know the administrative structure under Income Tax Act, appellate structure under Income Tax Act. You can't say abhi start hua. You have read something in already cmainter, maybe 1961, but you have read. Hai. So when you're reading some law, these things become important. So you have some grievances under company law, you got to know, okay, I have to go to NCLT. And sometimes to prevent those grievances only, NCLT. Administration, so we are saying Ministry of Corporate Affairs, assisted by Rita Aunty. Who's Rita Aunty? Secretary. No sir, not that secretary. Here secretary means IAS. We're talking about secretary having technical expertise. Do you think Nirmala ji has technical expertise? May not. It's not possible. You don't expect ministers to have that. So they need some secretaries. Personal secretary is different. Rita Aunty might be personal secretary. We're not talking about that. Come on. So we are talking about the ones which are going to provide the technical support. They are experts. Okay, so this ministry is assisted by secretary. So if you ask me the rank, I cannot say after ministry secretary. That's why I've written in bracket assisted by secretary. DGCA, regional director, we have ROC, we have official liquidator. Okay, now define RD. Don't say regional director. We know that full form. It's written there. RD. Sir, an administrative officer. Administrative officer heading a particular region. Heading a particular region. Administering Companies Act. Yes or no? Come on guys, he's an administrative officer. Heading what? A region. And administering what? Companies Act. That might not be the technical definition, but then whatever we understand, at least we should try to present it. Isn't it? Express it. That's what I'm trying to do. Come on, define ROC. See, there's a definition of ROC given under Companies Act. I don't want that definition. Simple definition. Whatever is your understanding. Administrative officer. Maybe at state level, sir. At state level, maybe. For the purpose of administration of Companies Act. Simple. Clear? See, the whole of the country is divided into states, you'll say. But states are grouped into regions. How many regions are there at present? 10. Earlier it was 7. Now it has become 10. Oh, blurred image. But at least you could see some regions, right? And if you see ROC, see, state-wise, but then some state 2 ROCs also. Like Maharashtra, 2 ROCs, Tamil Nadu, 2 ROCs, like that. And this 7 sister states, but 1 ROC, like that also situation is there. So there are exceptions. Anyways, so 10 RDs are there, and then some ROCs are there. Sir, we want to know exact number of ROCs. We want to know exact number of ROCs. Okay. You go to MCA website, you will get it. Anyways, so the whole of the country is divided into regions. And in regions we have got states. Region is headed by regional director. State is headed by ROC. DGCA is next in the hierarchy to MCA, Director General. Okay. And MCA, DGCA is for the whole of the country. We don't have 3 DGCAs. We don't have 3 MCAs and all. Okay. You'll say, no sir, 2 ministers are there. No. Array, that is the deputy. Correct? No. Harsh Malhotra. Website you have seen? No. Okay, sir. Official liquidator will have role in winding up. Will have role in winding up. Okay, sir. Someone there. Maybe at least we got to know. Right? If we don't know exact role, at least this much. Because winding up topic not there for us. At least we got to know. Next, suppose some court passes some judgment. Do you think judge only will go and see whether it is executed, followed or not? No, sir. How can he do that? Judge giving order, judge only checking? No. Official liquidator. Clear? So we have something like this. Okay, these type of, you can take a pic if you want to of this MCA headquarters. Already taken? No, I will not share that PPT PDF because I have observed students don't write them. And this is my, what do you say, hard work or my experience which I have put in this PPT. So I don't. I will share the other PDFs. When I start writing, no, those handwritten PDFs of topics I will share. Sorry, beta. Okay. So tomorrow I'll discuss a bit about this. Okay. And then we will close this basics and overview of Companies Act. Hardly few things are left. But definitions will take some time. As you could see, I've written even definitions. So some important definitions we'll see, like director, board of directors, MD, manager, officer in default, officer. These are important terms for us. So we'll see those definitions as well. So tomorrow's class again will be dedicated for this basics and overview plus definition. Okay. So with this, thank you so much. God bless you all. Have a great evening. And any concern, any doubts, any problem? No, all of you are able to follow? Sure. Great. Thank you. Yes, my dear YouTube live students. Please respond if it's okay. And can I close the session? Okay. Thank you. Bye-bye. Yes. Bye, Ishwar. Thank you. Sumedh. Bye. Thanks.